user data privacy in blockchain, ensuring GDPR compliance. And our expert, Benjamin Docquir, is going to present it. Benjamin leads the Osborne Clarke IP, IT, and data team in Brussels. His expertise encompasses technology law, data privacy, and digital regulation. His practice is a mix of transactional advisory and contentious work for both international and Belgian clients. He's a recognized expert in data protection and digital regulation with hands-on experience in the TMC, life sciences, and financial services industries. His practice covers algorithms and artificial intelligence, data pooling and sharing projects, international data transfers, and other regulatory challenges. Welcome, Benjamin. And when you're ready, you can start sharing with us your presentation.
Thank you, Lucas, for the kind introduction. Let me share indeed my screen. You should be able to see it now. Do you confirm?
Yes.
Okay, thank you. So good morning, everybody, and thank you for being with us up till now. Because I am the last speaker, I will try to shorten a little bit the presentation to keep it concise and really stress the key message that I want to deliver. So rest assured, it will be about legal stuff, but hopefully not too complex nor too boring either. So ensuring GDPR compliance in the context of blockchain and protecting user data privacy rights, data protection rights, is it possible at all? That's in a nutshell the question I would like to discuss briefly with you today. And I will spoil the end of the presentation and already give you the answer. Yes, it is possible. But first of all, I think it's useful to keep in mind the context, the background in which we are asking the question. The background is the MOLIERE project and the idea to develop an MDM mobility data marketplace ecosystem where mobility data will be shared essentially through thanks to the intervention of an operator of the central marketplace. And when I say central, it can be decentralized in a technical way. We've discussed that at length earlier today, this morning, I mean, but let's call it a central marketplace for the time being. And it will be accessible to a variety of mobility services provider. It will, and to additional other types of service providers as well. And the user will be at the center of all this data sharing, in the sense that there will be information about individuals using transportation means of all kinds. And that information will be recorded, will be accessible to the various mobility service providers, and will enable also the development of potential commercial offerings. So the question is it how to deal with data privacy and data protection law and regulation in that context? In order to answer that question, one needs to investigate first whether the infamous GDPR, the General Data Protection Regulation, applies or not to such mobility data. In spite of the fact that blockchain technology is being used for this decentralized database or the making available of the data that is being shared. As I said, the answer is yes, because I said it is possible to comply with GDPR. So the assumption is that GDPR applies to that mobility data. Why is that so? Because GDPR has a very broad scope of application. Its intention is to protect and safeguard privacy and fundamental rights in more or less any types of context in which an individual can be either directly or indirectly identified or can be identifiable thanks to various information about that individual or relating to that individual. So with that definition, you can understand that the intention of the lawmaker is to have a very broad, all-encompassing scope of application for the GDPR. And the specific question in the context of blockchain is, because the data is to some extent encrypted, is to some extent, well, the nominative information about an individual may not be directly visible to the various users of the system. So thus GDPR applies in that context as well. And that's what I want to stress and make it clear to everybody that the answer is affirmative. Because GDPR has this very broad scope of application, it does not suffice to say that the name of the individual is not visible or the other personally identifiable information is not visible. It does not suffice to say so or to argue so to conclude that the regulation does not apply. It will still apply. And it will apply as long as there is a possibility for somebody to identify or to re-identify in a way, to trace back the identity of the individuals thanks to the information that is made available and potentially additional information that one has in its possession in another context, for instance. So that means that the regulation, sorry, that means that the regulation applies to our mobility data, but that does not mean that the mobility data, that there would be any kind of prohibition to use or to make accessible that mobility data. It is possible to exploit the mobility data. It only needs to be done in taking into account the key principles of the GDPR. And I'm mentioning the key principles in the sense that I want to summarize, but of course one has to comply with all the legal provisions of the GDPR, but it's useful to highlight what the key principles are. They are listed on the slide here, and I don't want to go into each and every one of them in very much great level of detail. I want to maybe stress some of them. One of the key principles is transparency. So users need to be made aware that their information, their mobility data is likely to be used, to be accessed, to be exploited by the operator of the MDM, by the mobility service providers, and potentially also by other types of service providers. When one says that the data is likely to be exploited, to be used, it doesn't mean that it is free to be used by anybody for any type of purpose, because another very important principle of the regulation is that data must always be processed. That's a technical term we use as GDPR lawyers. Data must always be processed in relation to well-identified and precisely determined purposes, and these purposes need to be legitimate. That's also an important requirement. So if the data is being shared for the reason that we want to improve the mobility space in general, and because we believe that sharing the mobility data in the context of this marketplace is a good idea to make it accessible to certain service providers, there will still be a need to refine a bit and to define a bit further what the exact purposes of the use of the data can be, and the mobility service providers and the other service providers will need to respect these purposes and will need to limit themselves in the use of the data to these purposes.
Benjamin, sorry to interrupt. It's Lucas. Can you share the full screen, please? It's going to be better for the recording to present. The bottom
yes,
right.
I am in presentation mode, so
Okay.
I'm not sure what I should do.
Okay, don't worry, Ben. Don't worry. Continue, please. Sorry for interrupting. You can continue.
You're welcome. I'm sorry if it's not well visible for everybody, but okay, let's continue with the content and the presentation. So I wanted to highlight those key principles of the GDPR. And what I also want to do now is go briefly through the more practical, in a way, implementation of these principles. if one is going to comply with GDPR as an operator of the mobility data marketplace, how should these principles be translated into practice? And that's the scope of the following slides, and I'm going to go through them relatively quickly, but of course, please feel free to ask any question you would like, either while I'm talking or after I have finished my presentation. The first milestone on that journey to GDPR compliance is to carry out an inventory of the data, to map all the data points that that the operator of the MDM has in its possession, has access to, in order to draw a map in a way of the personal data that is being used in the context of that system, and to be able to create possibly distinctions between categories of data that are being used for certain purposes, whereas other categories of data are being used for other types of purposes, or maybe sometimes used only for certain sub-purposes in a way. The second very important step will be to define clearly as possible through contractual arrangements the respective roles and responsibilities of the different actors, the different players that come into this scene of an MDM ecosystem. As I briefly mentioned, there is the operator of the MDM itself, but also all the other service providers, including the specific mobility service providers. And under the GDPR, it is important to understand that one can have different roles. One can have some degree of control and decision-making power as to the purposes of the data and also as to the means of the processing, which brings you under a qualification of a data controller. It means that it is the full-fledged application of all the GDPR provisions and obligations to you as the data controller. A data controller could be a company, a corporation. It can also be a group of legal entities acting jointly. So it is also possible to conclude that the ecosystem would be jointly controlled by several actors, several operators, in which case there would be a need to transparently also inform the users that the responsibilities are shared between those different joint controllers. In other situations, the degree of control that one has over the personal data is much lower, is much less. One will then be qualified as a data processor when one operates the data or accesses the data or stores the data on behalf of somebody else who himself is the data controller and defines the purposes for the processing of the data. A data processor under the GDPR has a lot of obligations, but more in terms of ensuring the security of the data, the confidentiality of the data, and let's say the absence of a further processing or a secondary processing for different purposes. So the processor is a little bit has a little bit of fiduciary duty towards the data controller to keep the data safe and to keep the data sheltered from a use for other purposes by other data controllers who would like to reuse the data for other purposes. Those actors, the data controller and processor, must enter into an appropriate contract, which is called a data processing agreement, but I don't want to go too much into those details. What is much more important to highlight at this stage is that the data controller must draft and publish a policy, which is a document that will inform the data subjects, that's the name we give to individuals under the GDPR, inform the data subjects about who is the data controller in the first place, for what purposes is the controller using the data, possibly disclosing the data to third parties, and in what context and for what specific purposes. The data controller is also under a duty to inform individuals in this policy about their rights to themselves have a certain possibility to control the use that is made of the data by requesting information, requesting clarification as to the types of data usage that can be done, the situations in which the data can be shared with the third parties, etc. These data protection policies are really a very important dimension of the GDPR compliance and need to be drafted with care, of course, and especially if the controllers are acting jointly, as I mentioned before, then the policy needs to be decided upon in a joint manner and needs to be published in a joint manner and needs to reflect the fact that the controllers are acting jointly, which doesn't mean, which does not prevent rather the consumer or the user, in case they want to enforce the rights, to act against only one of the joint controllers.
Benjamin, just sorry for interrupting. Can you go full screen, please?
I am full screen.
Oh, really?
Yeah.
Okay. For some reason, okay.
I can, if you want, I can try to do something like that. Is it any more visible?
No.
Is it easier to see?
No, it's less visible now. I mean, when I say full screen, I mean presentation mode. I
am in presentation mode.
Okay. So for some reason, it's not working for me. Anyway, forget it.
I'm sorry about it. I hope it's not making it too complex to follow. But still, I will continue. The next milestones of the GDPR compliance, the data controller needs to comply with the data subject right. As I said, there are certain ways for the data subject to control the use that is made of the data, typically to ask access and to ask information about the data that the data controller has and for what purposes it is using the data, etc. What is essential for the data controller is to have certain procedures in place to ensure that any request that is received from an individual is taken care of, is handled in accordance with the timeline that is dictated by the GDPR, which is in short 1 month after sending the request, the individual should receive an answer to that request, although there may be exceptions or specific situations, but that's a general rule, 30 days to answer, to react. And those rights can be pretty far-reaching in certain situations. The individual even has what is called a portability right, which would be the right for a user of a social media typically to have all his account information being ported, being copied and made available for use in the context of another social media operator. This portability right will not always apply in all situations, but I just want to use that case to explain that the data subject right is a very serious topic and can be a topic of concern for data controllers because it can in some ways impair their ability to have a monopoly over the data in a way. In addition to that, the data controller will need to appoint a data protection officer in certain situations. Let's say that the magnitude or the scope or the amount of data that is being controlled by the data controller will be a very important factor to take into account in the decision whether or not a DPO should be appointed. The DPO is a function that must have a very wide degree of independence within the organization and must be able to advise the organization about the implications of the decisions of the board's decision, implications from a data protection standpoint. It is meant a little bit as a compliance function in the financial industry to help an organization make sound decisions that respect the fundamental principles of data protection law. A little bit in the same way as data controllers are, in the sense that data controllers are encouraged to assess the risks and to have an internal function for that purpose, they also have the duty to perform what is called a data protection impact assessment. And that will certainly be the case when geolocation data will be processed and gathered and stored and reused on a great scale, as in the case of the mobility data marketplace. This data protection impact assessment is a methodology essentially to reflect about the technical, organizational, and legal implications of a project, like creating the mobility data marketplace, and assessing how it may be possible to anticipate potential threats or potential non-compliance areas, and to remedy those potential non-compliance areas. The next aspect is for companies or organizations to maintain a data register. As I mentioned in the beginning, one needs to create a data inventory. This data inventory needs to be kept up to date. The data will evolve obviously over time, and one needs to ensure that it still remains an accurate reflection, an accurate picture of the global situation within the company. Very importantly, a data controller needs to implement appropriate security measures, because they need to ensure the security, the confidentiality, the reliability of the data. So the data needs to be to remain fit for the purpose for which it is being used, of course, and one needs to prevent access, unauthorized access by third parties who would potentially change or manipulate the data. This is all part of the technical and organizational measures that companies, data controllers, need to put in place to respect GDPR. There are additional steps or milestones in the journey to GDPR compliance, because I'm conscious of the time that flies. I just want to highlight maybe one thing, which is the data minimization, which is a very important principle in the general data protection regulation. That is to say, in simple terms, that the data controller will always be accountable to demonstrate, will need to be able to demonstrate that it is only using the data that is necessary for the purpose that it is pursuing. So in the context of the mobility data marketplace, it is perfectly understandable that quite massive amounts of data will be necessary, but there is always a necessity or a duty to demonstrate and to be able to explain why exactly that category of data, for instance, is necessary and how it is not possible to do without it. So just to conclude about those various steps to take and the important milestones on the road to GDPR compliance, I hope it's relatively clear or understandable for you. I try not to make it overly complex, and I'm open to take any questions that you would have. Thank you.
Thank you, Benjamin. Now is time for your Q&A, and Jessica, you wrote something on the chat. I guess you have a question, more concrete question for Benjamin, please.
Oh, I just wrote something on the board, so that's not my question. Okay. And by the way, I do have one question for Benjamin here, and the question will be, you see, I want to know your opinion about some certain enterprises have their own KYC issues, know your customer for short. And will that be a nice thing, as you're concerned, to hold a unanimous criteria to handle all these issues? Or will there be some differentiations to separate, maybe geographically, that to make sure that we don't blur our standards to avoid to jeopardize the data protection from your point of view? Okay, thank you.
I'm sorry, I'm not sure I understand completely your question. Can you explain and give me maybe a practical example of what you mean?
You see some, it's like some, at a certain point, there will be some exchange who trades the crypto coins and they hold them their KYC issues. Since you talk about the future, and I'm talking about the now situations. So my concern is, will there be some like a red pill, blue pill thing in that jeopardized?
Apologies, but I don't feel.
I'm sorry, my circumstance a little bit noise, so maybe ignore me. Thank you.
Okay, any other questions for Benjamin? Okay.
I have a question if we have time.
Yeah, please.
Okay, thank you. First of all, thank you, Benjamin, for the presentation. It was very interesting. I'd like to ask very quickly, I know there's no time anymore, and we still have to hear from Joseph. Very quickly, how do you see the EU regulation to impact the blockchain-based systems, and are there any concerns related to that, and which are these concerns, if any? Thank you.
Yes, it's a very broad question, but it's useful because it allows me to highlight the fact that, let's say we could think about the GDPR as the first layer or the first floor of the regulation tower in a way, and there will probably be additional regulatory constraints or burdens in specific sectors, like maybe the mobility data space. And to the extent that blockchain would be used in that context, it is, in my opinion, likely that there will be a focus on transparency, much in the same way as there is in the GDPR, transparency and ensuring security. So using blockchain to facilitate data sharing, as such, the goal will not be prevented by European future regulations, in my opinion, or the way I understand it at this stage. But there will be additional duties. So in addition to the GDPR obligations, there will be duties to ensure that the data is shared in compliance with certain restrictions, for instance, in terms of the use or in terms of the confidentiality or in terms of who can access. And there will probably also be additional requirements in terms of the contractual arrangements between all those entities sharing the data, be it using blockchain or another type of technology.
Thank you very much.
You're welcome.